Ask us anything. The show title says it all, doesn't it?
It does, Kenny. You know, this is typically one of our better shows. You know, sometimes our topics can be a bit restrictive,
yeah,
and you know, there are a lot of you out there that do have a question on your mind. Sure. And instead of hoping we do the right show, this is a show to just call. So if you have that question, whether about divorce or something, maybe a municipal court, maybe an issue with a neighbor, workers' comp, car wrecks, property, divorce, whatever you have, just give us a call. We'll take your legal questions on the air.
Can you even do criminal calls?
Oh, yes.
Can you
yes.
do?
I can.
Will you tie
sure.
into that judge
yes,
experience?
I will.
Okay, very good. Over the email machine this week. Dan
Is that what they call it? The email machine?
The Google machine and the email machine. A creek separates my property from my neighbor. Neither of us own it, but it's part of the city's drainage system and is maintained by the city. If someone got hurt in it or around the creek, are we liable? Dan, great question. Matt, this is pretty common throughout South Mississippi.
It is. No, that is a great question. That has kind of a lot of component parts and touches on various things. First and foremost, if someone gets hurt and it's not your property, it's not, say it's on the creek and not on your land that you own, so obviously probably not.
Okay.
Okay, now, so if it is in the creek, which is owned by the city, that brings another issue, all right? Cities enjoy, to a certain level, it's called sovereign immunity. And whenever you want to sue a city or a municipality or a state government or a state entity, what you have to do is first of all, there's a short statute of limitations, 1 year, and also in addition, there's a requirement that you would do a tort claims notice as a prerequisite to filing the suit. And if you don't do that right, and if you don't do that on time, they throw your entire case out. So you've got to go to the statute, you've got to pull the books. Those notices are very tricky. There's been a lot of litigation about exactly what has to be in them to comply. So that's tricky business.
Now, say that again just a little bit slower. Tort.
Yeah.
You were rolling there. Tort.
Fast talker.
Yes.
No, tort claims notice. All right. Okay. The statute requires when they repealed. The states used to be immune from suit until 1993. Then the legislature rolled that back and they said, you can sue the state, but if you do, we're going to have some special rules. One of it is you have to give the city or the entity notice before you do so they can perhaps settle or take corrective action. So you have to do this letter, and the statute specifies exactly what has to be in the letter. You've got to send that, and for 90 days you can't do anything. You can't file suit, and that gives the entity time to do whatever it's going to do. And then after that 90 days expires, if you've heard nothing, of course, then you can file suit.
Let me do one real quick. Yeah. Last week we had Jim and Matt Lott on.
Okay.
And something we talked about that I heard a lot about this week, Matthew, we were talking about the fact that a jury most of the time or all the time cannot hear that there's insurance involved in a case. And I got stopped a couple times this week. People were like, is that really true? Is on a jury? Would you mind expanding on that one a little bit? Because it was a hot topic last week.
Yeah, I will, Kenny. And let me just say, let's just look at the numbers, for example, or statistics. If you're on a civil jury in this state, and probably most states, more than likely it's probably a car wreck. A tremendous amount of litigation obviously involves car accidents, 18-wheeler accidents, things like that. So you have somebody hurt or alleges that they're hurt, they're suing another party. All right, say, you get hurt, you sue me. Okay. Well, I have insurance on my vehicle, and part of that policy is they will provide a lawyer, the insurance company pays for it, but we can't disclose that at trial. The courts have determined in Mississippi, and a lot of other states too, that it's too prejudicial for you to be able, as the plaintiff, to tell the jury that, well, it's not, Matthew's not really paying, it's his insurance company paying, so you should give me good money because it's really not coming out of this guy's pocket, it's his insurance. But I can tell you, every single case where there's a jury, there is insurance. But we can't tell you that. That's something that can't be disclosed. In fact, if it is, it's grounds for a mistrial.
How about
means sending everybody home, a do-over, and you've got a very angry judge. So absolutely every single jury trial, environment car wreck case, the other side is insured. And they're getting their lawyer paid by the insurance company. And of course, if there's a verdict or recovery, the insurance company has to pay that pursuant to the terms of the policy.
My question is if a person is arrested for a criminal offense, let's say breaking and entering or mischievous mischief or even arson or something like that.
Okay.
If he's arrested and he waives his preliminary hearing, can he be brought to trial without the grand jury indicting him? Without going through the formality of grand jury indictment?
That's a great question, Richard. Yeah, let me just kind of let's talk criminal law, basic criminal law 101. Whenever someone is arrested for a felony charge, what they have to do within 72 hours of being incarcerated, they have to do what's their initial appearance. And several things happen at the initial appearance. One is you have to be formally told what your charges are, so you know what you're facing. Okay, that's number one. Number two is you have a bond, whether you're entitled to a bond or what the amount of the bond, so a bond setting. And the third thing is a preliminary hearing. Everybody that's in charge with a felony has the right to request or demand, it's your right, a preliminary hearing, and that's a very low-level hearing that the state or whoever, the prosecuting agency, has to put on proof to a judge, probable cause that a crime was committed, probable cause you were, the perpetrator of the crime. So that's kind of the threshold. Now you can waive that right, okay? As a criminal, you can say, that's one of the things the judge will ask you. Do you want to waive that right or no? You're supposed to also sign a form if you waive that right. So once that's done, and then once you post bond, then you're of course out on bond. You're on your own recognizance with a bondsman, and the case then is supposedly then sent to the grand jury. Okay, the DA is supposed to then takes jurisdiction of it, and it goes to the grand jury. So short answer is the grand jury then has to kind of also pass on it as well. So also, it's got to go to review to a grand jury.
I gotcha.
Yes.
And I'll tell you on that preliminary side, just from the media side, my old reporter days, that's where like WLOX and reporters, you get a ton of that early information at that preliminary trial.
Every prelim, I mean, as a city judge, I'm the guy that does the initial appearance on all felonies inside Ocean Springs. And so, but I promise you, every preliminary hearing, the media is always here because a lot of information comes out.
It is, and because the trial could be literally a year, 2 years down the line, it might be a long time. So a lot of times, when you just insider tip, a lot of times you'll hear the news media, that's where they get is that preliminary court hearing.
They want to be at that prelim, and absolutely.
Which might be a reason you might want to avoid that if you were in that situation.
I would say about my experiences, Kenny, about 95% of the folks waive the preliminary hearing. Divorces, they can go kind of two ways, right? One is the agreed divorce, which is both parties kind of come together and say, this is not working, we have irreconcilable differences, and we agree to split. All right, you hear about that a lot, and that's usually done in about 60 to 90 days. The other way is a contested divorce.
Right.
And in that case, a lot of times one party wants a divorce and the other party may not want a divorce. And in that case, if you're the party asking for the divorce, you have to prove grounds in Mississippi. We have, we have statutes, the legislature passes rules, and in fact, they even amended one of the rules this summer about domestic violence. So there are, 13 grounds for divorce in Mississippi: adultery, abandonment, habitual cruel and inhumane treatment, so those kind of things. So you have to put on that kind of proof. So, don't want to get into those kind of details, obviously, on this kind of forum, but that's something you have to do. People do it. I know your husband, that's, it's emotional. It's very emotional, very difficult process. Obviously, you can hear it. You hear the heaviness in her voice.
Very heavy.
And, but in the end of the day, generally speaking, if one party does not really want to be married to you, ultimately you will get a divorce, in the end. So, and as part of that, usually, and economic coercion, think about that as well. You said you don't have the money. Well, usually the courts kind of address that pretty soon in a temporary hearing, and so the party that's, for example, if you're the homemaker, for example, and he works outside the home and it's his money and not your money, the courts kind of handle that as well, so you can, represent you can have representation and you can get some relief. You're not just kind of stuck because you don't have the money, you can't get a lawyer. So that's, listen, it's really, you have a lot to talk about. This is not kind of the forum to talk about it. I would really call a competent divorce lawyer, make an appointment, speak with them, and kind of take that step. And what you really need to understand is what your rights are, and you need to look at the facts of your case and then compare it to the law and really see what you're looking at here. The simple fact is you may not have enough evidence to prove a divorce on a contested matter, or you do. And so that's something you need to talk with a good lawyer about and kind of come up with a game plan to decide how to proceed forward.
And Matt, we're kind of over time here, but Carol, this is an important one to me. When she goes and talks to that attorney, first off, the first visit, generally, you lay it all out there and it's not a cost for that. But the confidentiality is what I want to talk about.
Yeah, two things. Yeah, divorce lawyers, and sometimes two. Some of them do. That's something you get up front. The good ones will usually speak to you, especially in your situation, Carol. They should talk to you for free, and you need to get straight in the front end before you even go down there when you call just to set the appointment. And the second thing is absolutely, Kenny, confidentiality. There's a privilege, what it's called, between a lawyer and its client, and the law respects that, meaning that the lawyer can't disclose it, you can't disclose it, they can't. Even the courts, a subpoena can't make that be disclosed. So that way it encourages full disclosure. You can tell your lawyer anything, and that way you don't feel that, oh gosh, it's going to get back. It's going to get back, and they're not supposed to tell, obviously, nor they can even be compelled to tell. Of course, and I know lawyers that have even gone to jail by refusing to give that right. And so it's one of the great parts of our legal system.
Yeah.
So.
All right. Carol, thank you so much for the call tonight.
Yeah.
We really do appreciate your sincerity. We'll be thinking about you. Hope everything
issue
works
with
out.
the house, Corey, is was there a will? Okay, when your mother passed, so that's the first issue. If there's a will, the confines or the direction in the will has to be followed. So if she put in there specifically who it would go to, then that's what must be done. And to do that, you have to go to probate court. You have to go to chancery court, and you have to go to the judge. And the purpose of that is so the judge can then reissue ultimately a correct title and kind of clean up the title. Because right now, what you have is you have a house owned by your mother, and of course, she's deceased. She's not available to sign paperwork. And in the chain of title, you can't have a gap in the chain of title. So that's one issue. So if there was no will, all right, there was no will, which is common, what happens is the laws of intestate succession in Mississippi apply. And what that is, they have rules. They say if there's a will, we're going to follow the will. But if there's no will, these are going to be the general rules. And for example, if a wife dies, the rules say, well, everything goes to the husband. Okay. Well, if husband dies and wife dies, and everything goes in equal parts. So that's the way it kind of has to go. And long story short is, if all the children get equal share in the house, okay? And so nothing could be done unless everyone agrees, everyone signs off. And if everyone doesn't agree and everyone doesn't sign off, you then have to go to court. Only Chancery Court has the jurisdiction to kind of come in there and kind of, I don't want to clean this up, but to keep the chain of title going. And the issue is, Kenny, and how this kind of becomes important, because if you don't get this cleaned up, if you don't get this all nice and tight, the house becomes unsellable.
Oh, gosh.
Because you can't get a mortgage, because you can't get a title opinion, you can't get a mortgage, and there you have it. I could go on for hours, Cora.
I could tell.
I could go on for hours.
I wish you would stop.
I'm not going to stop, Kenny.
Good night, everyone. Thank you for joining us. We'll see you next week.
Good night.